Debt collectors often threaten to sue you to get you to pay your outstanding debts. Collection agencies have the legal right to take you to court to collect overdue bills, but will they do that? If they sue you, what should you do? I'm Doug Hoyes, a licensed insolvency trustee with Hoyes, Michalos & Associates. Today I'm going to talk about dealing with threats of legal action from debt collectors. The likelihood of a debt collector suing you is very low. Suing someone costs money. There'll be costs for lawyers, paperwork, court fees. A debt collector will weigh these costs against how much they think they can collect. Now, it is very common for a collection agent to threaten to take you to court, but most of the time they don't actually start legal action. Why? Well, the most common reason for not suing you is that your debt is too small. The cost to take you to court may be more than what they think they can collect, so it doesn't make good business sense to sue you. Collectors also won't bother to sue you if you're considered creditor-proof. You're creditor-proof if you don't own any assets that can be seized or don't have any income that can be garnished. We have an entire video on understanding when to ignore creditors because you're creditor-proof. I'll put a link to that video at the end of this one. Another reason a creditor likely won't sue you is that you live outside of Canada. To sue you, the creditor would need to take you to court in Canada and in the country where you live. This can be extremely costly, involving double sets of courts and lawyers, so it would take a very large debt to make this worth the effort. The final and most important reason to not expect legal action is that your debt is too old. Every province in Canada has a Limitations Act that defines the time limit for a creditor or collection agent to use the courts to collect. In Ontario, it's 2 years. If a creditor tries to sue you after the 2-year mark, you can file a statement of defense saying the debt is past the limitations period. The limitations period doesn't apply to all debts, so before you decide to just ignore a debt because it's old, you should seek professional advice. Again, we have a complete video on the statute of limitations linked to at the end of this video. So now we know when a debt collector might not take you to court. What do you do if your debts are large enough or new enough that they will? If a creditor decides to pursue you through the court system, they'll send you a notice of legal action or a statement of claim. You have a set time limit to dispute or accept this claim. In Ontario, it's 21 days. You need to issue a statement of defense or attend the trial to tell your side of the story. If you don't, the court will likely rule in favor of the creditor. If the court rules for the creditor, the court will issue a judgment. This is a court order stating that the debt is legally owed by you and gives the judgment creditor the legal right to take legal action to collect. If the creditor wins the case, they can garnish your wages, freeze your bank account, seize non-exempt property, or file a lien on your property. You can stop these legal actions by paying off the debt, or if you can't afford to, by filing a consumer proposal or bankruptcy. Both options provide an automatic and immediate legal stay of proceedings, protecting you from any actions a debt collector might take. If you need more advice on dealing with debt collectors, watch the videos linked at the end of this video or visit us at hoyes.com.